So for us, as a department and as a faculty, we believe that any party who wins in an arbitral proceedings is entitled to the fruit of the award. Then similarly, a party who also feels genuinely concerned can also ventilate its grievances. And thank God that Nigeria did, and then the finding was that there was merit in the application to set it aside. As they say, the taste of the pudding is where? Is in the eating. So the speaker had prepared something. So help me to welcome him as he takes the podium. Mr. Dele Ogun, let's clap for him.
Well, good afternoon. Can I begin by thanking the University of Lagos for this opportunity to address you. I wish that there had been a microphone stand, because when I speak, I normally like to gesticulate, and my hands are now restricted. At least I'll be able to gesticulate with one hand rather than two. But I begin by saluting this university and the dean in particular for leading this very important conversation on this fundamental case that endangered, as Professor Sunny said, it endangered the whole practice of international arbitration. So this is a case that we must not let go of. We're in a legal season, and let me begin by saluting our brothers in South Africa for their leadership with respect to the proceedings that they issued before the International Court of Justice concerning the developments in Palestine. This is the essence of law. If law is to be meaningful, it is most meaningful where it changes lives and changes the course of history. So we salute our brothers in South Africa for their courage and their initiative. This is a quotation from John Ruskin, a great philosopher. He said, "Whatever the learning or acuteness of a great lawyer, our chief respect for him depends on our belief that set in a judge's seat, he will strive to judge justly, come of it what may. Could we suppose that he would take bribes and use his acuteness and to give plausibility to iniquitous decisions? No degree of intellect would win for him our respect. Nothing will win it short of our tacit conviction in all important acts of his life. Justice is first with him, his own interest second." Can I check if I can operate without this microphone, because it seems to disappear in and out, and my voice without the microphone is actually quite loud. Shall we try? The virtual audience. Well, blame the virtual audience, because otherwise you will have had the richness of Dele Ogun's voice. let's move to the fundamental issue. Underlying the practice of international arbitration is the freedom of parties to agree how, where, and by what rules of procedure they wish their disputes to be resolved. In the trade, it is called the principle of the autonomy of the parties. It is fundamental. The fundamental requirement of the principle that whatever the parties agree in this regard must be recorded in a written agreement, signed by the parties. Now, this is eminently sensible requirement to avoid disputes about what was agreed. In most contracts, the parties go no further than that. They simply agree the headline that their disputes will be resolved by arbitration, by a panel made up of an agreed number of arbitrators at a specified location. Sometimes it's a single arbitrator, other times it's a panel of three. And where it is a panel of three, the claimants would select his arbitrator, the respondent or defendant will appoint his own, and then the two arbitrators so selected will, between them, agree on a chairman. That panel comes together. What they then do is to adopt the detailed, this is when I say they do, these are the parties to the dispute, the claimant and the defendant. They adopt the detailed rules of procedure of one of the established arbitration centers across the globe. London, Paris, New York, hopefully one day Lagos as well. And those arbitration centers will invariably provide for the arbitration hearing to be conducted in private, away from public scrutiny. Now, this is the essence of arbitration. It's the privacy of the proceedings. Recognizing the danger that justice behind closed doors, which is the appeal of arbitration, can easily turn into arbitrary justice. The local law may prescribe some safeguards. The UK Parliament, for example, in section 68 and 69 of the Arbitration Act 1996, has sought to balance that freedom of the parties to decide how they wish to resolve their disputes with the wider public interest in ensuring a fair and just hearing. While the parties are left free to agree that there should be no appeal to the courts if the arbitrators get the law wrong, the UK Parliament has prescribed an irreducible minimum of judicial oversight over the work of arbitrators by allowing an aggrieved party to file a claim to challenge the award in certain limited circumstances. The courts have made it clear that this is a mandatory provision that cannot be contracted out of, and so in favor of party autonomy is qualified to this extent. One circumstance where the parties can ask the courts to intervene is where the arbitrators have committed, and these are the magic words, a serious irregularity which has caused substantial injustice. Policy background to this safeguard in English arbitrations is to be found in the report of the Department's Advisory Committee on the Arbitration Bill. It is as follows. It is really designed as a long stop, only available in extreme cases where the tribunal has gone so wrong in its conduct of the arbitration that justice calls out for it to be corrected. On the other hand, the DAC recommended adoption of, quotes, the internationally accepted view that a court should be able to correct serious failure to comply with the due process of arbitral proceedings. The ethos of the DAC report was that parties are entitled to a fair hearing leading to an impartial adjudication. It is a byproduct of the principle of party autonomy that the courts are concerned to ensure that once the parties have freely agreed to have their disputes resolved by arbitration, they are to be held to all the consequences, and no party should seek to evade those consequences by running to the courts as an afterthought. The red line that the courts tend to apply in supervising arbitral awards is due process. This reflects the fact that the essence of arbitration is that it is a process agreed by the parties for the resolution of their disputes. It is the process that is fundamental. Provided the agreed process is followed, the courts are not concerned to review the correctness of the tribunal's decisions. The guidance in the DAC report that I referred to earlier is clear. The test of, quotes, substantial injustice, end quotes, is intended to be applied by way of support for the arbitral process, not by way of interference with that process. Thus, it is only in those cases where it can be said that what has happened is so far removed from what could reasonably be expected of the arbitral process that we would expect the court to take action. The test is not what would have happened had the matter been litigated. To apply such a test would be to ignore the fact that the parties have agreed to arbitrate and not to litigate. Having chosen arbitration, the parties cannot validly complain of substantial injustice unless what has happened simply cannot, on any view, be defended as an acceptable consequence of that choice. That brings us nicely to the P&ID case, where we were faced with the prospect of dishing out 11 billion US dollars to what turned out to be a case company with no staff, no offices, not even a website to collect 11 billion US dollars. I dare not try and convert that to Naira at the current rate. I think even your Department of Mathematics would probably struggle with that conversion. Now, the commercial deal in the P&ID case can be easily explained. We produce gas in great quantities as an offshoot of our crude oil production, and that gas has historically been flared by the production company rather than being harnessed for the electricity that we're desperately in need of. The environmental damage caused by gas flaring is immeasurable, and the opportunity cost to the country's GDP is tremendous. So the deal with P&ID made commercial sense from beginning to end. Nigeria would pipe the natural gas, which is called wet gas, to a production facility which P&ID was to build and operate. That's the fundamental to the legal analysis that should then have followed. They were to build that plant that was going to convert the wet gas into dry gas. At the facility, P&ID were to remove the natural gas liquids from the wet gas and return dry gas to Nigeria, which we would have used for power generation, etc. This was trade by barter, effectively. No money was to pass. P&ID was to build the production facility, and they would keep the natural gas liquids which they extracted from the wet gas, and Nigeria would have the dry gas. Plain and simple, fair and square. The gas supply processing agreement was signed on the 11th of January 2010. It was to run for 20 years from the date of the first regular supply of wet gas by the government. But by 22nd of August 2012, P&ID was initiating arbitration proceedings against us, in which it was alleging breach by the Nigerian government and claiming damages of US $6 billion plus interest. The amount claimed had been calculated on the basis of the money that P&ID would have received from the sale of the natural gas liquids had the contract run its 20-year course. This was yet another one of those agreements where, although almost every aspect of the contract touched and concerned Nigeria, the arbitration process itself to have very little to do with this country, despite the governing law being agreed to be Nigerian law. The critical clause in the agreement read as follows: the agreement shall be governed by and construed in accordance with the laws of the Federal Republic of Nigeria. The parties agree that if any difference or dispute arises between them concerning the interpretation or performance of this agreement, and if they fail to resolve such difference or dispute amicably, then a party may serve on the other a notice of arbitration under the rules of the Nigerian Arbitration and Conciliation Act 2004, which, except as otherwise provided herein, shall apply to any dispute between such parties under this agreement. Within days of the notice of arbitration being issued by the initiating party, the parties shall each appoint an arbitrator, and the arbitrators thus appointed by the parties shall, within 15 days from the date of the last arbitrator was appointed, appoint a third arbitrator to complete the tribunal. The arbitration shall be final and binding upon the parties. The venue, and this is the critical word, the venue of the arbitration shall be London, England, or otherwise as agreed by the parties. The arbitration proceedings and record shall be in English language. The arbitration hearing duly took place in London before a panel of 3 arbitrators. Sir Anthony Evans, a retired Court of Appeal judge, Chief Bayojo, a senior advocate of Nigeria and former Attorney General of the Federation, and Lord Hoffman, a retired law lord. The 2 British members of the panel found in favor of P&ID, with Chief Bayojo filing a dissenting decision. If time allows, later I'll come back to Chief Bayojo's arguments. The issue now became the enforcement of the award against the federal government of Nigeria. After having participated in the proceedings, the Nigerian government now argued that the award could only be enforceable as a Nigerian judgment, while P&ID argued that it was enforceable as an English domestic judgment. The answer to this tug of war of jurisdiction depended on whether the seat of the arbitration, because those are the magic words in international arbitration practice, the seat of the arbitration was Nigeria or the UK. Now you see why I opened with my comments about the tombstone and the drafting of the headstone. The words matter in legal drafting and have heavy consequences. The federal government of Nigeria rushed to its own courts to get an order restraining the parties from further steps in the UK arbitration process, arguing that its agreement that London should be the venue of the arbitration meant no more than the geographical location for the hearings. So it's a bit like when Nigeria plays some international football matches. It may be Nigeria against Poland, and the venue of the match is Wembley, England. That is what we intended. P&ID, on the other hand, refused to engage with the Nigerian proceedings and ran instead to the arbitrators for ruling the, quotes, venue of meant the same as the seat of arbitration, so that English law applied, with the consequence that the award was enforceable by the English courts in the same way as a domestic judgment. The Nigerian government got its order from the Nigerian courts, and P&ID got the ruling that it wanted from the arbitration panel. When P&ID made an application to the court in England for permission to enforce the award against the federal government of Nigeria, the government opposed the application. The case was heard on 14th of June 2019 before Mr. Justice Butcher, who began by reciting what we know about arbitration principles. He said and emphasized the consensual nature of arbitration and the importance to be accorded to respecting the integrity of the party's choice. So as far as he was concerned, you've chosen England and you're stuck with us, was his attitude. He went on to, again later, if time allows, I'll share with you certain aspects of Butcher's judgment. He went on to criticize the federal government of Nigeria's case by saying the ruling by the tribunal on the seat of arbitration could have been subject to challenge pursuant to Section 68 of the Arbitration Act 1996 on the basis that there had been serious irregularity affecting the tribunal, the proceedings, or the award. Or it would have been open to the Federal Republic of Nigeria to attack the final award pursuant to Section 68 Arbitration Act 1996 on the same basis. It did neither, and the time for doing so is long past. Now, to give context to the time for doing so is long past, time limits in English litigation are strictly enforced. If you're a day late, you're dead and buried. It's only in very exceptional circumstances that they will reopen the matter. In this case, Nigeria was 4 months late. And so Butcher was saying, tough. He went on to consider whether there were any grounds of public policy on which the by now US 9 billion award, because of course the interest was running at £1 million a day, whether there was any grounds of public policy on which the $9 billion award should not be enforced. He cited several authorities and stating that it has been shown that there is some element of illegality or that the enforcement of the award would be clearly injurious to the public good, or possibly that enforcement would be wholly offensive to the ordinary, reasonable, and fully informed member of the public on whose behalf the powers of the state are exercised. But he went on to rule as follows. I am clearly of the view that there is no public policy which requires the refusal of enforcement to an arbitral award which states and is intended to award compensatory damages, and where, even if the damages awarded are higher than this court would consider correct, as to which I express no view, that arises only as a result of an error of fact or law on the part of the arbitrators. The enforcement of such an award would not be clearly injurious to the public good or wholly offensive to the ordinary, reasonable, and fully informed member of the public. Furthermore, the public policy in favor of enforcing arbitrary awards is a strong one. And if a balancing exercise is required at all, it outweighs any public policy in refusing enforcement of an award of excessive compensation. The labeling of such excessive compensation as punitive or penal, as the Federal Republic of Nigeria seeks to do in this case, does not alter this conclusion. We were truly dead and buried at the end of that judgment. We had to pay the $9 billion. It was at this point that I was consulted unofficially by a Nigerian chap who was acting for a US law firm that was involved in the arbitration as to what could be done. And my advice, based on my past experience, was that at this point, you need to turn it rough. You don't play by the rules. You have to go for the jugular, make it dirty. And that figure of 11 billion US dollars, turn it political, because that's the only way law is over at this point. It is the publicity that will damage international arbitration. If that award stands, that will force them to back off. I'm sure we're going to come to the judgment of Mr. Justice Robin Knowles later, but I suspect that my time may be up at this point. I'm told that I have 10 more minutes. All right. In which case, what I'd like to do is to share with you the aspects of the dissenting opinion of Chief Bayojo, which all of you lawyers would immediately connect with, to say, of course, that makes sense. That's how the case should have been decided. He said in his dissenting judgment, the majority opinion appears to have set up a case better than and different from that canvassed by the claimant, by suggesting that the claimant had the capacity to do more than one work at a time. It was stated that an employee who is dismissed can find another full-time job. But there's no reason why P&ID should not have pursued more than one investment opportunity. The issue of the ability to do more than one work is at variance with the claimant's case. It is on record that the claimant stated that it devoted, quote, substantially the whole of the time and resources of its team on this project, and that it placed on hold another project. This is clear admission that the claimant lacked the capacity to pursue more than one investment opportunity at the same time. So, to break it down, the Chief Ojo was saying, in the context of this duty to mitigate its loss, that how can you possibly award them damages on the basis that this contract would have run for the 20-year period, and that they had no obligation to mitigate? So how does that make sense? Yes, an employee is an exclusive arrangement, and in theory, a self-employed person can run with more than one commercial opportunity at the same time. But this particular company, on its own case, had said, we've devoted everything to this project. We don't have the capacity to run with anything else. There's another comment that Chief Ojo said. As I earlier stated, contrary to the suggestion of the majority, the claimant clearly admitted its duty to mitigate by stating in paragraph 28 of its written reply on the issue of damages that, quote, it is accepted that P&ID was under a duty to mitigate its loss whether as a matter of Nigerian or English law, this admission cannot be disregarded. So elementary contract law, that if a contract is broken and you have a claim for damages, you're not entitled to fold your arms and put your feet up on the desk and say that I will collect all the money that I would have received had that contract not been broken. You have a duty to mitigate your loss. Find something else to do. Common sense. And Chief Ojo was saying it does not matter which law you're applying, whether English law or Nigerian law or the law of the planet Mars. The same fundamental common sense results should follow. At paragraph 12 of his dissenting judgment, he said, "It is not tenable to award damages on the supposition that the claimant will not be able to find alternative work or alternative projects for 20 years. It's simply not possible that if they have the skill and expertise that they lay claim to, it should only be a matter of months, if not at most a few years, to get another opportunity. They should be queuing up." Here's another passage from Chief Ojo's judgment that I liked. "In any event, it is absurd or anomalous for a claimant to admit the existence of a duty on itself and then, without any evidence by way of discharge of that duty, for the majority opinion to state that the respondent has not proved what other work claimant would have undertaken." Let me break that down for you. The majority was saying that it was for Nigeria to prove and show the other work that P&ID could have done, which is in all legal principle on its head. Why is it for Nigeria to prove what other work P&ID could have done? And Chief Ojo said the party that has the duty has the burden to prove the discharge of that duty under Nigerian law. The claimant clearly bore the duty to prove its efforts at mitigation. This is the 419 of international arbitration that this case has exposed. And we only got this exposure because the numbers were so outrageous. I argued the case before the same tribunal, not the same members, but the same center, the Court of International Arbitration in Fleet Street, London, where we were robbed of $5 million US. And the law was plain and simple. But because it was only $5 million US, they buried it. I talk about the case in both the P&ID case and that case that I'm referring to in this my book, because the only way that justice systems will run properly, as we saw in the case that South Africa brought before the International Court of Justice, is when the whole world is watching and everybody is looking and everybody knows what's really going on in those courtrooms. So the more publicity, the better. There's a passage in Justice Butcher's judgment that I want to share with you. This was during the tug of war. Just think how insulting this comment is. When you think we're supposed to be a sovereign and independent state. At paragraph 28 of his judgment, he said, on 26th of April 2016, the tribunal made procedural order number 12. It stated at the end, place of arbitration, London, and was signed on behalf of the tribunal by Lord Hoffman as presiding arbitrator. Procedural order number 12 was to the following effect. In light of the ministry's commencement of proceedings in the Federal High Court in Lagos, it was apparent that there was a dispute between the parties as to whether the Nigerian courts were entitled to exercise supervisory or curial jurisdiction over the arbitration, and that this depended on whether Nigeria or England was the seat or place of the arbitration. It was stated that this is an important question, not only for the purpose of determining the jurisdiction to supervise the proceedings and award, but also for the purpose of the enforceability of the award. And in that procedural order number 12, this body of arbitrators, private individuals, led by Lord Hoffman as the chairman, had ruled that the high courts in Nigeria had no jurisdiction over this dispute, which concerned Nigeria's oil and gas. Truly remarkable. I'm being warned that I'm down to my last 2 minutes. I will simply end on a macro note in terms of international arbitration. It is a huge industry. The fees that are generated by the main arbitration centers, annual fees from arbitration, cases that really do not touch and concern Paris or London or New York or South Africa. It's a huge cake. I haven't got a precise figure. In fact, no, I do have, if I find the chapter, I do have the precise figure of how much the London courts are seeing from international cases. And we are missing out on that huge cake, where we are, even the cases that should be heard here, such as the P&ID case, are being carried off to be deliberated upon in England. I'll share with you this, quickly read this passage to you. As Heathrow and Gatwick airports are to international travel, so the courts of England are to world trade. This is no accident. It was a core part of the economic revolution that Margaret Thatcher put the British economy through while she was Prime Minister from 1979 to 1990. She had identified Britain's competitive edge to be in the service sector, exploiting the fact that so long as English remains the world language, the dividends of empire will continue to flow. In her blueprint for Britain, banking, insurance, air travel, and legal services were to take the front line, with manufacturing relegated to the back row. As it concerned the legal sector, English law English courts and English arbitration was to be sold to the world. Wherever possible, parties to international contracts were to be encouraged to adopt English law as a law to be applied in resolving their disputes. A British government press release of July 2018 reported that, quote, English law is currently used in 40% of all global corporate arbitrations. Revenue generated by legal activities in the UK was worth £31.5 billion in 2016. Even in cases where English law or hearings in England had not been expressly agreed by the parties, many cases ended up in the English legal web because money had passed through British banks and ended up in English real estate. A case in point was that of Frederick Chiluba, president of Zambia. After he left office, proceedings were brought in the High Court of England by the new government of Zambia, who accused him of looting the Zambian treasury during his period of office from 1991 to 2001. At the end of the trial, a judge in England ordered this former president of Zambia to repay approximately £23 million to his country. As it is for court trials, so it is for arbitration. Thank you very much for listening.
Thank you very much, Dele, for that powerful and incisive presentation.
Let me hand over to Mr. Ogun, yes, to address some of these. You can sit if you would like.
Thank you for those questions and the comments. Let me start with the mention of Priti Patel. Very correct. This was the former, I forget what her cabinet position was, Home Secretary of Great Britain, that was effectively threatening to blacklist us in terms of international trade unless we coughed up the what was then $6 billion US. They were desperate to get hold of our money. And anyone who sees Priti Patel anywhere, and I'm speaking to those online, especially in the United Kingdom, do ask her how the market is at the current time. I was grateful for the insight into the Esther Code factor in terms of these agreements saying that the venue will be London, that everybody wants to get London, all expenses paid. Somehow we have to get the message across that it is not worth exposing your country to potential loss of 11 billion US dollars just to have a flight to London and stay in Park Lane. Is simply not worth it. The point about how this tribunal managed to interpret the venue for an arbitration as being the seat of the arbitration. The explanation is very simple. They were a dishonest panel of judges. It's as simple as that. Everybody who thinks that judges, lawyers are not dishonest when nobody's looking. The test of law and lawlessness is what you do when you think nobody is watching. It reminds me of a news report in London. There was a High Court judge who traveled on a train each day to the High Court. And he used to leave his, he'll be standing, insisted on standing, and he'll leave the zip of his trousers down with his vital particulars exposed. And a lady who used to travel on the same train decided to follow him one day to say, who is this guy? And she followed him into the High Courts. And that's how it emerged that this fellow was indeed a High Court judge. These are just human beings. We sometimes pay too much reverence, especially to those who are wearing funny clothes, whether uniforms, whether gowns or wigs. Is up on the reverence. They are all human beings. The point about DFID's intervention from Dr. Was it Olawi that I took down? Yeah, a very valid one. It goes to show that everybody wants a slice of that cake. Struggle to get a larger chunk is political. So you use all your departments. So the departments for international development are not interested in international development. They've never developed anywhere. Which part of the world has the Department for International Development ever developed? They should properly be named the Department for International Underdevelopment, because they are in there for Britain. They're batting for Britain, and they will use whatever muscle is available to make sure that those that cake, the British part, is larger and juicier. The student asked a question about publicity and the other side of the argument that publicity can distort justice. I think the important keep in mind is this: that principle is valid in criminal cases where public opinion can sway the jury, for example. Where you're dealing with hard-nosed business issues, the more publicity, the better. This is business. This is not emotional. These are deals. And doing it in private is a license for judicial corruption. Somebody online asked a question, what's wrong with using illegally or improperly obtained documents? In principle, there's nothing wrong with this in litigation. If the other side are negligent and documents that ought not to be disclosed are disclosed, that is one. But what was happening in this particular case, and bear in mind it was in the context of whether the judgment should be enforced as a matter of public principle. In this case, this was systematic handing over of confidential legal advice. So it's like playing a game of cards, and you can see the cards of your opponents. So wherever is going to move, you're already ahead, and then you're seeking for the courts to help you to enforce that judgment. That was what the issue was speaking to. Somebody mentioned the point about, it's Chukuma online, that insurance companies insist on foreign arbitration. That is correct. What do we have to take away from that point? It is a political point, that if your government is weak, then foreign insurance companies, organizations like DFID, individuals or characters like Priti Patel will keep taking as much as possible. They'll grab. And so it is a responsibility, it's a challenge to governance. We've got to get our governance system stronger, because right now we are bleeding, and we have been bleeding systematically since so-called independence. They are getting richer, and the gulf is getting bigger, and it will continue to grow bigger as long as our governance systems are weak. Politics is serious business. It impacts not just this generation, it impacts the generations to come. How can international arbitration be improved? Simple. Follow the advice of Mr. Justice Knowles, who said it is time for a discussion as to whether this practice of arbitration hearings in private ought to be abandoned. It should be public hearings. If they're going to say 2 + 2 = 5, let those judges say it publicly so we know who they are. As it stands, the confidentiality of arbitration allows them to, as you saw in this case, principles of basic law, the duty to mitigate. Former law lords who were on the panel could say, no, it doesn't apply. And it is for Nigeria to prove and show how P&ID could have mitigated its loss. What nonsense. Finally, somebody asked the question, what can we do on our side? I think the lady doctor asked that question. What can we do on our side? First of all, we must do what we're doing right now. So this is why I was commending University of Lagos for taking the lead. Ordinarily, that judgment would have been noted and forgotten. Here, you're forcing a discussion, and people online are listening and taking notes. But it mustn't end here. The NBA, the least that they can do is run with this case. Let us examine it further. Let all the lessons that are available to be learned, let them be learned. Thank you very much.